So the Supreme Court is reviewing a case which will help to bring an end to the ATF's current overreach and their attacks on the Second Amendment. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this video, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, look at legal protection because it's smart just in case you have to ever use your firearm self-defense. I recommend USCCA, and you can check them out using the link down below. As I mentioned in the intro, in this video, we're going to be discussing an important case which is currently set for Supreme Court review and which the Supreme Court has granted review in. The case we're going to be talking about is called Loper v. Ramonda. And this case is not a Second Amendment lawsuit, but it still has huge implications for other 2A litigation and other lawsuits which are currently going against the ATF's current overreach. This case can help stop the ATF's pistol-based rule, their bump stock bans, their frames and receiver rule, and other actions that the ATF is engaged in. The Loper case is a lawsuit which aims to bring an end to Chevron deference. Now, like I mentioned, this case is not directly a firearms case, but it's still a challenge to the executive agency's overreach, which goes beyond the agency's statutory authority. Now, the facts around this case are as follows. Loper Bright Enterprises is a family-owned herring fishing company that operates in New England. On these small boats, every inch of space is very valuable to store supplies, to house the fishermen, and then to also store the fish that they catch. However, the herring industry in the area came under attack because of a new rule issued by the National Marine Fisheries Services. This regulation requires that herring fishing boats must have an additional person on board to serve as a monitor. The rule requires this additional monitor so that the boats are in compliance with the tracking compliance required by federal regulations. Not only does this monitor take space on the boat, but the fishermen must also pay that monitor's salary, which is estimated to be around $700 per day. The facts of this case show that the new regulation requiring this mandated monitor reduces the fishing profits by about 20%. And if the fishing boats decline to actually have that monitor on board, well, then they are not permitted to fish. Loper Bright and other fisheries sued to challenge this rule, arguing that the NMFS lacked statutory authority to force them to pay for these monitors. Ultimately, their challenge was this. There is nothing in the federal statute that requires these boats to take a monitor with them and to pay that person's salary. On review, a district court held that the statutory text did authorize this new rule. Loper Bright then appealed, and the DC Circuit Court held that the statute was ambiguous, but then the court deferred to the agency's interpretation under the doctrine of Chevron. Loper then, in response to that decision, filed a petition up to the Supreme Court in which the Supreme Court just granted review. In their recent order, the Supreme Court stated that the petition for a writ of certiorari is granted limited to question 2 presented by the petition. Justice Jackson took no part in the consideration or decision of this petition and these motions. So Justice Jackson is recused from this case as well. So there's only going to be 8 justices that hear this case. Now, question 2 that the court referenced in granting review of this case was presented by Loper Bright in their petition. And that question that the Supreme Court will review is whether the court should overrule Chevron or at the least clarify that statutory silence concerning controversial powers, expressly but narrowly granted elsewhere in the statute, does not constitute an ambiguity requiring deference to the agency. So the Supreme Court will hear this case and decide whether or not they want to overrule Chevron altogether, or at the very least, are they going to greatly limit the ability of agencies to use Chevron whenever they want when a statute is silent on an issue? Now, if you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a Supreme Court case called Chevron v. Natural Resources Defense Council. This case establishes the concept of courts upholding agencies' interpretations of ambiguous statutes that Congress has tasked that agency with implementing. However, generally, for an agency to be given Chevron deference, the agency's interpretation of that ambiguous statute must be rational or reasonable. So when a statute is ambiguous in some way, the agency responsible for enforcing that statute may be able to determine what Congress intended as long as their interpretation is rational or reasonable. In contrast to Chevron deference, there are other concepts. For example, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous statute in a way that is most favorable to the people, not the enforcement agency. There is also something called the major question doctrine, which the Supreme Court recently used, and they used it last year in a decision called West Virginia v. EPA. Under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national significance, its action must be supported by clear statutory authorization. What the Supreme Court indicated in West Virginia is that agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Instead, the court is now establishing that if Congress wants to give an administrative agency the power to make these types of decisions, it must state that fact clearly and expressly in the statute. Now, you may be asking yourself, why does this case have any impact on the Second Amendment? Well, right now we are seeing the ATF and other federal agencies that deal with firearms being very aggressive in their rulemaking processes. For example, just in the last 5, 6, 10 years, the ATF and other agencies through rulemaking have issued rules banning various items, attacking various items like bump stocks, pistol braces, frames and receivers, homemade silencers or suppressors, a lot of different items, and it doesn't seem like these agencies are going to stop anytime soon. This is all primarily being done through the ATF claiming that they have broad statutory authority given to them under the NFA and GCA to make these types of rules. If Chevron is completely done away with, then the ATF's claim that they have this type of authority will no longer be valid. And I think the ATF knows that Chevron is soon going to be done away with because a lot of times in their recent lawsuits, they've tried to stray away from arguing Chevron as their main support for their rulemaking process. Sometimes it will still be granted to them by courts, even though they waive Chevron deference, but they've tried to stray away from it and just say, well, under the plain text of the NFA or GCA, it expressly gives us the ability to do these types of things. For example, with the bump stock ban, the ATF claimed that the term machine gun was clear in the statute and that the term includes bump stocks. In fact, I believe the ATF never even raised Chevron in those arguments. So for a while now, the ATF has known that Chevron is likely going to be done away with. It's on life support, so they've just kind of tried to stray away from it. But that hasn't prevented justices, liberal, left-leaning judges in courts from still granting them Chevron deference. But this decision in Loper, in combination with maybe other lawsuits which are seeking Supreme Court review, like the Cargill bump stock lawsuit, if that is also granted review, well, then it would be a very significant 1-2 punch to very significantly decrease the ATF's authority, to constrain their authority, and almost do away with all of their rulemaking process that they're currently trying to implement. Now, we still need to see how significant and how broad-reaching this decision by the Supreme Court will be in the Loper case. We're still waiting for all the briefs to be submitted and then oral arguments, but it's going to be really interesting to see how this plays out and if really we are in the last days of Chevron deference. But with everything the ATF is currently doing, this is one of those very significant cases that we need to keep our eye on. We need to track because, again, this may not deal directly with 2A issues, but it's going to have broad implications on all the litigation that's currently going on, challenging the ATF, the federal government, and also likely state governments. But if we get any more information, I will let you all know. Also, if you want to learn more about what's going on in the 2A world, you can watch some of these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.